So the Supreme Court just denied review in another Second Amendment case, and this one involves the ATF's new rule which magically changed bump stocks into so-called machine guns. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is LAS Concealment. If you don't know about LAS Concealment, do yourself a favor and make sure you check out their website. They have an assortment of Kydex holsters for a broad range of handguns, almost everything you could think about in various types of configurations with lights, optics, etc., and a bunch of different colors and designs as well. For example, one of my EDC holsters for my Glock 43 is one of the LAS Concealment holsters with the side magazine pouch. So I love this holster. I use it a ton. If you're interested, go check out their website. You can find them at lasconcealment.youknowwhat. And thank you again, LAS Concealment, for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we'll be discussing how the Supreme Court once again denied review in a case which challenges the ATF's recent rule change and their recent regulation of bump stocks, and how the ATF is now treating them to actually be machine guns, how they are treating these pieces of plastic, these devices, to actually be machine guns within their own right. The case we're going to be talking about in this video is McCutcheon v. US. In the past, we've discussed some other bump stock cases, including the Apashian case, the GOA case, and also the Cargill case. Recently, the Supreme Court denied review in two of those cases, the Apashian case and the GOA case. And a couple of years ago, the Supreme Court also denied review in a different case. And so the Supreme Court recently just has not been wanting to touch this issue of bump stocks. Currently, there's another case challenging the ATF's bump stock rule, and that is the Cargill case. And that's still waiting for review by the Fifth Circuit en banc panel. This case, McCutcheon, which the Supreme Court just denied certiorari, which means they denied review, challenged the takings clause and the takings aspect of the ATF's bump stock rule, and the change, which is very relevant not just for what the ATF is doing in regards to their actions against bump stocks, but also the types of actions they're taking in regulating various types of firearms and devices as well. These new attacks by the ATF against frames and receivers, pistol braces, all of those stem from the first attack by the ATF and the changing of their rules and changing the treatment of bump stocks as actual machine guns. For many years, the ATF had correctly concluded that the NFA and the GCA's definition of the term machine gun does not include devices like bump stocks. However, after an incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners of bump stocks were required to either destroy the devices or to surrender them over to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of $250,000 if they failed to comply with that new rule and destroy those devices or surrender them over to the ATF. In this case, McCutcheon, the petitioners are owners and sellers of bump stocks. These individuals acquired the bump stocks when they were lawful to purchase, lawful to possess, and lawful to sell, and that was all in accordance to what the ATF had said was in fact lawful. The plaintiffs in this case actually complied with the new rule when it was dropped down by the ATF, and so in compliance with that new rule by the ATF, they destroyed their devices and they surrendered them as well. After that, the plaintiffs then sued the ATF because they were seeking just compensation because of the taking of their private and personal property. They just surrendered those items, they destroyed those items, so they wanted at least just compensation from the federal government. This case then made its way up to the U.S. Federal Circuit Court of Appeals, who rejected the plaintiffs' Fifth Amendment claims. In that decision, a majority of the panel held that there is an inherent restriction on title to any piece of property in America that is potentially subject to a federal agency's generally delegated legislative rulemaking authority. In simplest terms, the court rejected the plaintiffs' claims that there was any constitutional taking as a result of the new bump stock rule that the ATF put in place. This was because the court found that your right to personal property is limited when an agency like the ATF has rulemaking authority over those types of items. This almost means that you never have 100% possessory and personal property rights to anything related to firearms or any related devices, since according to this court, the ATF has regulatory authority over them. Therefore, one of the logical concerns from this decision is that the court is trying to create a limitation on your right to possess firearms and other related items through the ATF's regulatory powers. As a result of that decision, this case then made its way up the Supreme Court and was seeking Supreme Court review. As the petitioners stated in their writ of certiorari, the Federal Circuit's holding raises fundamental questions about the nature of personal property in a nation in which nearly every object is subject to some sort of general grant of legislative rulemaking authority. If the Federal Circuit Court is right, the petitioners argue then federal agencies can, with a stroke of a pen, outlaw not just the future sale, but the mere private possession of cars that burn too much gas or light bulbs deemed too inefficient, and so on without any payment, not even paying a single dime of compensation to their owners, because obviously, according to this court, you don't have a possessory right to those items at all because the agency could always outlaw them. They go on to state that under the Federal Circuit's decision, citizens and merchants alike are left with no recourse to forced seizure and destruction of millions of dollars worth of lawfully acquired property. Now, one of the interesting things about this ban as well, which is pointed out in the petition, is that the ATF did not even decide to try to grandfather in the bump stocks that were possessed, purchased, sold, etc. under their prior guidance. They decided not even to grandfather those items in as well. They decided to just completely ban the possession, sale, and all of that of bump stocks and require that all of them be destroyed or surrendered over to the ATF. The petitioners claim that the ATF could have grandfathered in existing devices and imposed its ban on a prospective basis, meaning they could have just simply applied it going forward. After this date, you can no longer buy new ones or possess new ones. You can only have the ones that were grandfathered in. But the ATF did not decide to do that. They just went full bore and banned the possession of all the devices that were purchased and sold under the direction of what the ATF said was lawful conduct, essentially. Now, unfortunately, the update in this case is that we received an order this morning from the Supreme Court that they have in fact denied certiorari in this case. They've denied review in the McCutcheon case. Now, this case was much narrower in its focus since it dealt primarily with the takings clause and how the promulgated new rule created an unlawful taking of various types of devices. The three other cases denied review prior by the Supreme Court were much broader and dealt much more generally with the general rule and the Second Amendment implications and also other violations as well, including takings violations. However, the Supreme Court denied review in those cases as well. So now we have 4 bump stock cases over the recent 4 years, 3 years, something like that have now been denied review by the Supreme Court. Now, like I mentioned, there's still the Cargill case that I mentioned earlier that's pending at the Fifth Circuit en banc panel level. And again, that deals with the ATF's just general bump stock rule, and it's much more a comprehensive challenge to the rule. That case is better suited because it's broader, like I said, but it could go a positive way. The Fifth Circuit could rule a positive way, but it's still got to go through the Fifth Circuit en banc panel, and then it's got to go up to the Supreme Court, and we don't know for 100% fact that the Supreme Court will actually take that case up. There is never any guarantee that the Supreme Court will actually take review of any case. There have been hundreds of great Second Amendment cases with great facts, legal arguments, and procedural posture that have made their way up to the Supreme Court in the past, but the Supreme Court is never obligated to review any case. And as of right now, the Supreme Court has essentially rejected 4 bump stock cases. And that's been 4 cases over the last 3 or 4 years. But you never know. Sometimes the Supreme Court could surprise you. They could decide to take that Cargill case. But again, it's never a certainty. And as of right now, based on the track record of the Supreme Court, that would be the indication that maybe they're not interested in at least taking up a bump stock case in dealing with this type of issue. Maybe they'll do it through a different type of case. But as of right now, the Supreme Court has rejected once again another bump stock case. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.